Hello, everybody. Thank you for having us today. My name is Juan Carlos Branda, and it's a pleasure to have you one more time in this show with one of the attorneys in the law firm of Margaret W. Wong and Associates. And today is an awesome day. We are matching, but just for some reason, I don't know why we are matching today. But one good thing is that the colors in Margaret W. Wong and Associates is red color. So we're wearing red today. And today I have the attorney, Retanio Rocker, who is one of the attorneys in the law firm, and he has a lot of experience. He has been a judge, and I'm not sure if he was a prosecutor as well, but he's going to clarify that for us in this show today. So please feel free to send your questions today. All the questions and the answer are going to be free for you. And if you have any other questions, you can call. The phone number is 216-279-3984. 216-279-3984. Hello, Attorney Retanio. Thank you so much for having us today. How are you doing?
I'm well. Thank you for having me, Juan Carlos. I appreciate it. How are you doing?
I'm doing good. I'm doing pretty good today. It's a little cold here in Atlanta, which is not normal because at this time we have around 85, 89, but now we have like 56. So that's good.
Well, here in Cleveland, we are still cold. We're waiting for springtime to show up. It has not yet. So although I have on short sleeves today, I have a much warmer jacket upstairs.
Yes. Well, a couple of years ago, someone mentioned in the office that there would be snow in June or May in Cleveland, and it actually snowed in May. So
that is true.
It was funny because I didn't believe that was going to happen, but that actually happened on that year. So thank you so much for your time and talking about the weather and about everything that's going on. Um, One of the things that people are seeing right now is that uh, this thing about the Title 42 at the southern border, and some people that have come in to the United States with their kids. So, what is the thing about bringing your kids if you want to become an immigrant in the United States?
Well, the whole Title 42 piece gives you an opportunity, supposedly, to come in with your children. And under the new administration, they're not trying to separate children from their families like was done under the previous administration. So you should have an opportunity to do that. And if your children are non-US citizens, then we have a situation that we call ward of court that you can apply for in the United States in terms of seeking status and attempting to adjust your status. And ward of court, you have to be very careful about what state that you do the ward of court in, because a majority of the states, such as here in Ohio, are only up till 18. But normally, like in Alabama, I believe, Mississippi, Maryland, and some other states, you can adjust up until you are 21. So the whole purpose of it is not to separate, at least the policy of the current administration is not to separate children from their parents.
Okay, thank you so much, attorney. And one question that I received through our social media is um, when the child comes to the United States being under 18, um, in order to get the special juvenile status, we could talk about the process, but they have to be with no parents here in the United States, or they can be with one of the parents here in the US?
Well, that depends on the state. Recently in Ohio, in Stark County, we had a decision that was rendered by a judge, which we are going to appeal, that misinterpreted the federal statute. They don't seem to understand that the federal statute has in fact changed. It used to be that you didn't have any parents here in the United States. But under the new statute, you can at least have one parent here in the United States, and they have misinterpreted that. So we are intending to appeal that to the Fifth District Court of Appeals here in Ohio. But generally, if you have no parents, you can seek that special status. If you have at least one parent, generally, you can seek that special status.
Okay, thank you so much. And well, is Georgia one of those states that are
Geor-
top in these cases?
Georgia is a state which will give you special status, but only up until you're 18. And I have not seen yet any opinions from Georgia that have misinterpreted the statute. But I can always do the research and let the people know the next time that I come on. But I haven't
Yes.
seen anything yet. Ohio is the only one that I am aware of at the moment that has misinterpreted that statute.
Okay, so this person is asking, I entered 4 years ago with my daughter. She was 9 years old at that moment, and right now she's 13. Her dad was violent with me in Guatemala, and that's why I took my girl and came to the United States. Now my question is, can we do this process even though she lives with me and we live in Georgia?
To the best of my knowledge, I believe that you can, but again, I need to do the research to make sure that Georgia is not one of those states that's misinterpreting the federal statute.
Okay, thank you so much, attorney. Don't forget that we're talking to the attorney, Britannia Rucker, who is a former judge, former prosecutor, and he knows a lot about the system, and he has worked a lot of years in these institutions. And now it's an honor to have him working with the law firm of Margaret W. Wong and Associates. So thank you so much, attorney, for sharing your knowledge to all the people that are joining us today. Let's see the question of Sean Patel. When can citizen child apply for parents who are here undocumented, and is DACA still on? I think it's two questions, actually.
I think it is. To the best of my knowledge, I do not believe there are some individuals who do have a DACA status. Yes. And I believe that we can still apply for DACA status, but that has been returned because under the previous administration, if you recall, DACA status was eliminated, basically. You can apply when you come into the country. Your children can, in fact, apply for the ward of court status. And again, it will depend on the state in which you live. I would suggest that you do it as soon as possible by contacting a qualified attorney or a qualified law firm and have them advise you relatively quickly as to how, when and how long and what the laws are for your particular state.
Okay, thank you so much for this answer. Don't forget the phone number is 216-279-3984, 216-279-3984. This is a very good answer for the attorney, from the attorney Britannia Broker. The next question is from Gautam. Good morning. I have TPS EAD and recently approved. Well, I don't get that part of the question, but still has a U visa pending. Can I travel with that advanced parole from the TPS? Will I have a problem having TPS and U visa pending but approved BFDEAD?
My understanding is that
bona fide or bona fide, yeah.
Okay. My understanding is that you do in fact have status, but I would be extremely careful about traveling outside of the country because you do not want with your U visa pending for them to state that you have somehow been going in and out unapproved. I would wait until your visa is approved. And then once your visa is approved, then at that particular point in time, I would consider traveling, but I would not take that chance at this point.
Okay, thank you so much. And yes, please don't try to do something that could affect your immigration case. But first, get the advice from the attorneys that really know about immigration. in the law firm of Margaret W. Wong. The phone number is 216-279-3984. 216-279-3984. This person is adding this part to the question. I have traveled twice with advance parole before. At that point, you visa was not applied.
Okay. Well, if you are applying for the U visa now, I would wait and travel. I would not travel. Under advance parole, if you have traveled previously, you should still be able to travel, but with your U visa pending, if you have a U visa pending, you do not want to mess up that status.
Okay. Thank you so much, attorney. And we have another question here, but let's just remind the people the phone number is 216-279-3984, 216-279-3984. The next question is from Atika Harir. How is it would it be to vacate a criminal conviction in order to avoid mandatory detention due to two crimes of moral turpitude?
That's an interesting question. As you probably know, crimes involving moral turpitude will get you quickly removed from the country. Unfortunately, they are like aggravated felonies. They will get you removed quickly. Now, it is not always that easy to vacate a criminal conviction. I don't care what state you're in. I don't care what county or jurisdiction you're in. A lot of it will depend on whether at the time that you either took a plea or you were found guilty, you were warned about that this could, in fact, affect your immigration status. Now, in Ohio, I can tell you it is an extremely advanced process in order to get that done, but we can, in fact, do it. There is a whole statute that tells you exactly what it is you have to do in order to do a motion to vacate a criminal conviction. Also, the other thing is it's going to depend on the conviction that you're trying to vacate. Generally, crimes involving sexual crimes are much more difficult to vacate than other crimes might be, lower level felonies and things of this nature. Murder convictions are very hard to vacate. Aggravated felonies are very hard to vacate. So.
Okay. Thank you so much, attorney. And I've heard that some criminal attorneys don't like doing this vacate process because this is what I've heard, that this brings bad reputation to the attorney. Is that true, or is just a way of thinking?
I believe that that's just a way of thinking. When you have a client, I don't care if they're a U.S. citizen client or a non-U.S. citizen client, you have to represent them to the best of your humble abilities. And the bottom line is, with many of our individuals in the immigrant community, they are not necessarily warned about what the consequences could possibly be for taking a plea. For example, I just wrote a 5-page memorandum for a client of ours, an immigration client of ours, who took a plea to a drug trafficking felony. Now, as many of you know, a drug trafficking felony will get you expeditiously and quickly removed from the country. Now, the memorandum that I wrote let the attorney know you need to have this plea vacated because the person had not been sentenced yet. And the reason you need to have it vacated is because she did not understand the consequences of her plea. And two, it does not appear that the court under Ohio law gave her the proper warnings when they took her plea to this drug trafficking case. I also made a suggestion to the attorney that even if the prosecutor wants to have her plea to a felony, try to find a felony that doesn't involve trafficking in drugs or selling drugs, because the bottom line is you might be able to get away with still being here in terms of not being removed from the country, even if it involves drugs. But if it is trafficking in drugs, it is a death sentence. They will try to remove you as quickly as possible. So the bottom line is that, one, don't do it. But if you do it, your attorney should know, one, that you are not a U.S. citizen, that you do not have legal status, and that you want to know what the consequences are. And you should let your attorney know that you want someone to advise him or her as to what the consequences could be if, in fact, you take a plea or you are found guilty of some of these crimes.
Okay, thank you so much, attorney. This is a very clear answer, and thank you so much for being so clear with these answers. I really, really like the way you are answering each one of the questions. So please don't forget that the office of Margaret W. Wong and Associates has over 14 attorneys that have experience and that are really experts in several branches of the immigration law and other laws that are connected to the practice of immigration. So thank you so much, Attorney Rutanio, for sharing your knowledge in the side of criminal law and immigration law. Thank you so much. The
You are
phone
more
number
than welcome.
216-279-3984, 216-279-3984. Next question, interesting question, sad, I would say. My son is waiting for an asylum application, but uh, not he was not thinking and drove recklessly. The police pulled him over, got arrested for no license, driving recklessly, and they had alcohol drinks in the car, so probably a DUI, but they were not drunk.
Okay. Well, that's interesting because in the immigration environment, a DUI is basically the kiss of death. I just had a case yesterday in Marion Municipal Court in which we have a client who, in fact, was arrested for DUI, and it was his very first traffic case. And my whole point was to go down and see the prosecutor to try to get her to understand that if he pleads to the DUI itself, it could be used against him by the immigration court as well as by the DHS attorneys, especially if you are being detained. They will hold you on a DUI, even if it's an allegation or a conviction, just because it's DUI. Now, is that hypocritical? Yes, it is. Because why? In the criminal justice system itself, there is a movement to reform bail, bond, whatever you want to call it. There is a movement. We are trying to move people out of the jails and not hold them in the jails. But ICE detention is totally different. Now, if your son is 21, then more than likely you are looking at him being held in jail if it is a DUI, or if he gets the conviction for a DUI, you are looking at the possibility that ICE could come and get him and hold him. So what you need is to have an attorney who understands the immigration law and who also understands how important it is not to have a DUI conviction. And that was my whole purpose yesterday. Now, we didn't resolve the case yesterday because the prosecutor I was dealing with had to talk with her supervisor, which I am grateful for. So we will come back sometime in June, and hopefully she will have good news for me because I explained to her exactly some of the same things that I'm explaining to you. But here's the thing. Do not assume that he was charged with DUI just because there were alcohol in the car. The fact that there was alcohol in the car doesn't mean that they will charge you with DUI. So find out what your son has been charged with first before you start making presumptions about what could possibly happen. But understand, if it is a DUI charge, he's got an issue. The driving recklessly could be an issue. I'm not so much worried about the not having a driver's license. We can work through that. But driving recklessly and DUI can definitely be issues in the immigration world.
Thank you so much, attorney, for this answer. And don't forget, the phone number is 216-279-3984, 216-279-3984. So the person in the prior question says that he or she wasn't informed, and the case was petty shoplifting.
Okay. That is not necessarily It depends on the wording of the statute in terms of shoplifting. That is basically a crime of theft. And in Ohio, petty shoplifting is defined by the actual dollar amount. So much less than a certain dollar amount is petty theft. Anything above that is a felony. It depends on what the language of the statute is. If the language of the statute reads a certain way in the state in which you were charged, then yes, it could in fact be a crime involving moral turpitude. But if it reads a different way, then it might not be.
Thank you so much, attorney. And well, we have several other questions coming in. I'll try. Well, we have time. We have time. Um, how bad are traffic tickets for an immigration case? Around 10 tickets for either speeding, running a stop sign, holding phone while driving. Is it very bad?
Okay, let me be real straightforward with you. 10 tickets, whether you are a citizen or a non-US citizen, is bad. Period. In the story. 10 tickets are bad. You don't need to be driving. You need to be Ubering or taking a taxi. 10 tickets? You have got to be kidding me. That is bad for anybody. I don't care who you are. Bottom line is, you need to resolve your tickets, but you also need to understand that in the immigration environment, that's deadly.
Okay. Thank you so much, attorney, for this answer. And yeah, that was straightforward.
They need to Uber. They don't need to drive anymore, or they need to have somebody drive them. 10 tickets? That's too much. That's too much.
It doesn't matter in how many years.
No, it doesn't matter. 10 tickets is too much. You shouldn't have that. Your driving record should not be like that. Okay. They don't even like that for US citizens. Trust me, I'm telling you. I used to be a city prosecutor one time. It's the kiss of death. They don't care how far back you go. It's the kiss of death.
That's right. And thank you so much for this answer. Um, Greetings to all from Mexicali, Mexico. Thank you, Jessica, for sending this message. Jimmy Rocondo says, "What is the path of having two misdemeanor charges in the first 5 years of acquiring citizenship?"
Some DHS attorneys and some immigration courts will try to definitely use that against you because there is a portion of the law that talks about having crimes within a certain period of time. It is not necessarily a good thing. All right. But it also is going to depend on what the misdemeanors were for. For example, if they were disorderly conduct misdemeanors, which are minor misdemeanors in Ohio, it shouldn't be that bad. But if it was an M1 assault misdemeanor, it could be a possible problem.
Okay, thank you so much. And well, we have more questions, but let me just make a little pause here to remind everybody that the attorney Margaret W. Wong has started this law firm 46 years ago in the year 1977, around February 1977. She started only with one desk, no secretary, and she has been working from the city of Cleveland, Ohio, since the beginning. So she expanded to 10 cities, and right now, she has offices in 7 cities of the United States: Atlanta, Chicago, Columbus, Cleveland, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one: 216-279-3984. 216-279-3984 is the phone number that you need to call in order to get an appointment at Get Immigration Advice. Don't forget that this space is only a reference for you. We give you answers from one of the attorneys in the law firm, but this is not actually a consultation. You have to call the phone number 216-279-3984, 216-279-3984, and make your appointment with one of the attorneys in the law firm. So let's go ahead and read the next question. Well, the person says the misdemeanors were credit card fraud of less than $200.
That's not good. That is not good. That is almost like felony fraud. It is not good. And if you can, you should try to get those vacated so that it doesn't affect your ability to adjust status.
Yeah. So this. Oh yeah, this person is looking forward to the citizenship. I think this person is already a citizen.
Okay.
That's
All
what
right.
I understand here.
Well,
This person is a U.S. citizen, but in the first 5 years of citizenship, did these two misdemeanors. So the question is, could the citizenship be taken away from this person?
it could, but that is also going to depend on some other things. For example, other than these two misdemeanors he had in the first 5 years, what is his rest of his criminal history like? Has he been clean since he acquired citizenship? Does he have any traffic tickets? Does he have any other crimes? It's a lot of it is going to be dependent upon how he has acted as a citizen.
Okay. Well, he's not yet a citizen. He's looking to be one. Okay, so you answered this already. Thank you so much for your answer and for clarifying this question. Jessica Rubio says, I signed my voluntary deportation back in 2010 out of the fear of remaining in jail an extended amount of time. I was sentenced to 180 days after taking a plea deal. I was banned 10 years. So I don't know what the question is, but probably she's still writing it. I don't know if you want to go ahead and answer.
Well, based on what I'm seeing, voluntary departure is 10 years. So she would have been eligible to come back into the country in 2020. So the question becomes, now that 10 years have passed, yes, you can. Yes, you can.
Okay. Thank you
And
so
if I were you, I would try to come into the country legally because you've already had a voluntary departure. So I would try to come in legally under a B2 visa or some other kind of visa, student visa, or whatever your particular country would offer. I would try to come in legally. And then at that particular point in time, when you are stopped at the border and they are talking to you, at that particular point in time, then you ask to apply for certain types of relief, like asylum and things of that nature. So, but yes, you can reapply is the answer.
Okay, thank you so much for this answer. Don't forget the phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to talk to one of the attorneys in the law firm of Margaret W. Wong Associates. We have time for one more question. So this person says, I left my former husband because he was always implying that I married him for documents and saying that he would call the police and immigration just to deport me. Is there a case that I could file? We have a daughter together. She was born in the United States. She's 18 months old, and he was very humiliated.
All right. Now, I'm making a presumption that your husband was a U.S. citizen. And if your husband was a U.S. citizen, if you are still together and you are still living together, which it doesn't seem like you are, but I'm not certain, he could apply for you for an I-130 visa. Now, depending on whether he was abusive to you or not, it is quite possible that you could, in fact, apply for what's called a VAWA, which is for domestic violence that is perpetrated by a U.S. citizen husband toward a non-U.S. citizen wife. In addition to that, if in fact you made a police report about this violence, you could also possibly apply for what we call a U visa, which is a victims of crime visa. So there are several things. I would not suggest, if he was in fact violent to you, I would not suggest asking him to apply for an I-130 for you, especially given what you said, that he thought you married him for the documentation anyway. I don't think that it would work out too well. And here's something else. If in fact you are still with him, then you need to reevaluate that, because if you are being victimized by someone, you need to reevaluate that, because that is not necessarily a healthy environment for you or your child.
Okay, thank you so much, Attorney Britannia Rucker. And the time flew today, so our time is up. So thank you so much for having us today for each one of the answers. I really like this point of view that you have, being a criminal attorney and also an immigration attorney, because we get to learn more, and we get to learn of many mistakes that Hispanic people make, especially driving under the influence. I don't know how often you got to see that in Cleveland or in Ohio, but here in Georgia, it still happens.
It does.
It happens.
And it happens here. And it's never, trust me when I tell you, it is never a good thing to either be accused of a DUI or to be convicted of one. It is never a good thing in the immigration environment. So my suggestion to all my Hispanic colleagues and friends out there, if you are going to drink, have a designated driver or Uber. Thank you very much.
Okay, thank you so much.
The third option, stay at home.
Yeah, that's even better to stay home because you are safe. Thank you so much, attorney, and see you next time. I hope you enjoy your lunch. And well, for everybody who has joined us today, thank you so much for joining. Don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. We send the greetings to the attorney Margaret W. Wong all the way to Chicago, Illinois, from Irving Sanchez Troches. I want to say hello to my lawyer, Margaret. So she's in Chicago today. Thank you so much. And don't forget, the phone number is 216-279-3984, 216-279-3984. See you next time.